State of Kansas versus Tremaine J. Robinson. Jared Regier, Assistant County Attorney appearing for the state. Mr. Robinson, are you here?
I am here representing the name, ma'am.
All right, you need to start your video, please. And you are, is it Tremaine or Tremaine?
The name I'm representing is Tremaine.
Tremaine. And how do you pronounce your middle name?
J.
Tremaine J. Robinson.
On and for the record, ma'am, I want to say that I want to give notice to reserve all my rights and inform the court that I'm not here to testify or plead. I'm here to make a special appearance to challenge the jurisdiction only.
All right, anything else?
Yes, I would like to see evidence of a charging instrument.
Were you not given a copy of the ticket issued by Trooper Collins?
The charging instrument that I am referring to is a sworn affidavit of the client, of the person that I've hurt.
Now, this is a speeding ticket alleging that you did on March 27, 2023 at 8:48 a.m. operate a motor vehicle in Butler County, Kansas at the speed of 92 miles per hour when the posted maximum speed limit was 75 miles per hour. So this would have been out on the Kansas Turnpike, Highway I-35. Now, what else were you wanting to know, sir, as the allegations against you?
I would like to see evidence of the affidavit of the people that I've hurt. This is a victimless crime if there's no one that I've hurt.
The flaw in that argument is simple but critical. Just because no one was hurt this time doesn't make the behavior acceptable. Speed limits exist for a reason, whether you personally agree with them or not. They create a standard that protects everyone on the road. Without those limits, one person's idea of a safe speed could be far higher than yours, turning public roads into unpredictable and dangerous environments. And when that happens, it's not just a theoretical risk. It could be your own family facing the consequences of someone who believes the rules don't apply to them.
Well, the victim would be the state of Kansas in that you violated the laws enacted to protect the people of the state of Kansas. But this is not the type of crime which would require or have individual names listed. So your next point, if any?
My next point is, as I said, ma'am, I'm not here to testify. I'm not here to plead. I would like to see the affidavit with 2 signatures for the person that I've hurt. If I didn't hurt anybody, there's no crime.
All right, well, I'm going to proceed. So again, Mr. Regier, are you ready to proceed?
I am, Your Honor. As a preliminary matter, it would appear that while Mr. Pate was still involved with this case, but before the motion in order to withdraw was filed by counsel in August, the defendant did file a piece of correspondence of some kind. It does appear to include a motion for discovery. However, that particular document would appear to be procedurally deficient. It does not appear to include a certificate of service. The only address listed appeared to be on page 1 involving the defendant, the traffic court clerk at an address both in El Dorado and in Topeka, as well as the office of the Attorney General. Certainly no service on my office, so there is that.
In simple terms, the documents weren't properly served, which means there's no obligation of the court to take the motion seriously. And ironically, the very lawyer who was dismissed earlier might have been able to prevent that mistake. Still, the prosecutor confirmed receiving a 7-page packet, and what's inside is something else entirely. Page after page, it aggressively pushes nearly every classic sovereign citizen argument you can think of, hitting each point with absolute confidence. but setting the stage for everything to unravel just as quickly.
Subpoena was issued July 7, 2023 for Trooper Collins. Then on July 31st came a correspondence from the defendant as referred to by Mr. Regier herein. Looks like it's about 7 typed pages, and as counsel said, it's entitled Challenge for Jurisdiction and addressed to Butler County District Court Clerk, Butler County District Court Clerk, Office of the Attorney General Derek Schmidt. And it mentions subtitles under the following case law. I request case 2023 TR 1193 be dismissed. Talking about municipal court, administrative law in the next paragraph, ministerial offices being incompetent to receive grants of judicial power from legislature, citing a case, looks like 140 California 1, stating that once jurisdiction is challenged, the court cannot proceed. Next paragraph, the law requires proof of jurisdiction to appear. Talking again about an administrative agency and tribunals, judicial tribunals. Alleged personal jurisdiction of the defendant is void. The court has no jurisdiction, no discretion to ignore what is alleged to be lack of jurisdiction. And then it is signed by a signature that I'm not sure I can make it out, but it says Robinson-Tremaine, J, beneficiary. The next page talks about a legislative act of constitutionality, substantial harm, right to a trial by jury, all power inherent in the people, legislative assembly. Officer Collins K issued the ticket summons on the side of the road and did so without an affidavit of complaint approved by the clerk of the court or judge. Quote, I request a certified copy of that complaint from my accuser stating who it injured. Continuing, quote, no bill of attainder or ex post facto law or law impairing the obligation of contract shall ever be passed. End quote. Then he goes on to request this Officer Collins, quote, speed detection device, including model and serial number and year installed, any documents pertaining to the training certification, disciplinary reports of the trooper, tuning fork calibration records, certification records for the device, more information about calibration records, device records. He says the information requested directly relates to reliability and accuracy of evidence against him. So he's wanting proof provided within 21 days, or an immediate dismissal based on Rule 12, which comes from the Federal Rules of Civil Procedure. Under 28 USC 1746, Section 1. And then it is signed declaring or certifying or verifying or stating under penalty of perjury under the laws of the United States of America, executed July 26, 2023. Again, signature, and then in brackets, Robinson, Tremaine, J, without prejudice. Pretty much the same things he's gone over before. Talking about the judicial officer has to cease because of the administrative law, and pretty much standard language that is used by folks who call themselves or are considered sovereign citizens.
She shuts it down flawlessly. It's almost as if she can sense the recycled arguments coming to the screen, even over Zoom. There's no hesitation, no reaction of surprise, just calm, controlled confidence. Her expression says it all. She's not impressed, and more importantly, she's heard every version of this before. What might seem persuasive to others barely registers here, because to her, it's nothing new, just another familiar script playing out exactly as expected.
Revocation of signatures on the final page 7, mentioning that, quote, it is on this date, July 27, 23, I, Tremaine J. Robinson, it's Tremaine-J, Robinson, in the county of the Seminole of the state of Florida and a zip code, a natural man, attorney in fact, as a living human being who's the beneficiary of Tremaine J. Robinson trademark. Swear that the information in my sworn statement is truthful to the best of my knowledge and understanding. I, Tremaine J. Robinson, beneficiary of Tremaine J. Robinson, revoke my signature on any and all pages of any and all tickets, summonses, contracts, and/or agreements signed by the side of the road of the state of Kansas by Officer Collins K., March 27, 23, and then signature authorized representative and attorney in fact. So after that document was filed pro se, apparently by the defendant, Mr. Pate filed a motion to withdraw due to the defendant wanting to proceed pro se. And that was authorized based on the previously referred to 7-page document. It would indicate at the time to the court that Mr. Robinson did want to proceed pro se. So Mr. Pate, attorney, was allowed to withdraw. And so here we are. Now, Mr. Robinson, normally I would be upset that you filed what appears to be in part a motion for discovery and you didn't get that. However, you did not address that document to anybody but Butler County District Court Clerk, Traffic Court, Butler County District Court Traffic Court. You sent one to a P.O. box in Topeka, and then you sent a copy of it to the Attorney General. But you did not send it to the Butler County Attorney. Therefore, he did not know you were trying to get discovery.
Ma'am, I do have a tracking number that says it was delivered at the Butler attorney.
Okay, well, that's not on file. What you want to present that at this time?
Yeah, someone signed for it yesterday.
Wait, are you seriously saying the motion for discovery was served just yesterday? You're telling the court you requested extensive records, everything from the officer's history to equipment details, and expected a full response overnight? That's not how reality works. Legal processes don't operate on instant turnaround, especially within the American system. Even under ideal circumstances, obtaining discovery can take weeks, which is exactly why procedural rules exist. Those rules set clear deadlines for filing and serving motions. And in this case, those deadlines have already passed, leaving the request not just unrealistic, but untimely as well.
And this document that I'm giving the benefit of, it's a multi-subject document, but this document filed by the defendant that I'm giving the benefit of including what he offers as a motion for discovery was not filed with the clerk until July 31st. So that was after the statutorily required 21 days. And then it was not filed upon the prosecutor who would have, or the witness who would have held any evidence, but rather again on Butler County Clerk in Topeka, Kansas, that to my knowledge doesn't exist, the Butler County Clerk in El Dorado, and Attorney General then Derek Schmidt in Topeka. And that's if it was served, if I take the defendant's benefit of the doubt, that it was saying it was served sometime yesterday before today's 1:30 trial, the court has to decide if that later time was reasonable. And I do not find that it was reasonably served on the county attorney. I am at this point going to say that any last minute motion for discovery is denied and we are prepared to go to trial. Now, I've lost you, Mr. Robinson. Are you still somewhere available?
No,
What are you doing there with your computer?
right now I was looking for a document, but no, I am not available for trial.
Going to proceed with trial. So please put yourself back in front of the camera. Follow the court's order, or you could be found in contempt. I don't want to do that. Thank you, sir. All right, Mr. Regier, did you tell me you did or did not have any opening argument or opening statements?
Your Honor, I did not specify one way or the other, but the state would waive need statements at this time. However, if the state would respectfully request leave the court to read from some Kansas case law put down by the Kansas Court of Appeals, which does appear relevant in this matter.
All right, you can document those for the record.
Yes, Your Honor. The state would now respectfully read from State v. Mayor. It's a Kansas Court of Appeals case, 466 P3D 1236.
Go ahead.
Your Honor, in that particular case, involved a sovereign citizen, where the court noted in the memorandum opinion.
Objection, hearsay. Objection, hearsay.
Case law is not considered hearsay or.
I'm not a sovereign citizen.
All right. Keep telling yourself whatever you need to hear, but confidence doesn't change reality. Sooner or later, that narrative collapses, and when it does, you're left facing the same facts as everyone else. And from where this stands, there's no ambiguity. We're calling it exactly what it is. This isn't a misunderstood position or a unique interpretation of the law. It's a familiar pattern of sovereign citizen arguments, and it's being recognized as such.
All right, he's not a sovereign citizen. Go ahead, Mr. Regier.
Yes, Your Honor. In that case, the Kansas Court of Appeals noted, quote, the defendant thinks the law does not apply to him. He avows that he, unlike other citizens, is sovereign and immune from prosecution. The court went on to address the issue of venue, which the court noted that, quote, venue is generally proper in the county where the crime was committed. I will address that momentarily, as well as referring to KSA 22-2602. Additionally, and perhaps most relevant to this court, the defendant in that case, quote, complains that his objections to the trial court's jurisdiction to prosecute him arise from the claim that he is a sovereign citizen. This is not the first appellate court to deal with such a claim. Another panel of this court used analysis of federal case law to reject a similar claim. And then quoting from Seventh Circuit and Eighth Circuit cases, quote, an individual's belief that his status as a sovereign citizen puts him beyond the jurisdiction of the courts has no conceivable validity in American law, regardless of an individual's claimed status of descent, be it as a sovereign citizen, a secured party creditor, or a flesh and blood human being. That person is not beyond the jurisdiction of the courts. These theories should be rejected summarily, however they are presented. In referring to an Eighth Circuit Court of Appeals case, United States v. Yagam from 1992, Yagam found similar issues were completely without merit and patently frivolous. It rejected those issues without expending any more of these courts' resources on their discussion. And again, the Supreme Court also referred to a Kansas Supreme Court case from 2019. Quote, our Kansas Supreme Court has recently affirmed the Requena paddle. The court held that the claims of sovereign citizenship are ultimately meritless. Thus, if the defendant's arguments are on appeal, rely on his sovereignship claims, we hold they are meritless. And with that, I would respectfully call my first witness to the stand.
All right. I do find that this court has jurisdiction and venue to proceed, and the arguments made by the defendant in the 7-page document referred to previously are summarily dismissed.
And in a result that surprises absolutely no one, the court swiftly denies the frivolous motion to dismiss. With that out of the way, we're going to skip past the officer's testimony. It's lengthy but largely straightforward, and move directly to the moment that matters most. This is where things get interesting, as the defendant finally gets a chance to cross-examine the officer and challenge the details of the traffic stop firsthand.
And did you ultimately write the defendant a citation for speeding?
Yes, I did.
Or an annual redirect, no further questions.
All right, Mr. Robinson, this is your opportunity to cross-examine the trooper. You can question him about his testimony. It's not quite time for you to give your own testimony, so these addresses to the trooper have to be in the form of question. You don't have to question him, but you can. Would you like to?
No.
All right. Mr. Regier, any further evidence?
None from the state, Your Honor.
The state rests then, Mr. Regier?
The state does so rest, Your Honor.
Mr. Robinson, the state rests. They have presented all the evidence they intend to. Would you like to present any evidence? Again, you don't have to. Your silence will not be used as a sign of guilt. But if you'd like the court to consider your position, I'd be happy to do so.
I don't understand.
Well, do you want to tell the court your version of what happened?
No.
All right. You don't wish to present any evidence then. Am I understanding you correctly?
The evidence that I tried to present, you won't give due process.
You claim a lack of due process, yet no actual evidence has been presented. Only a motion to dismiss that the court has already denied. At this stage, arguments alone aren't enough. If there is any real evidence to support your position or any testimony you intend to offer, now is the time to bring it forward. This is the moment where claims must be backed by substance, not just assertions.
Okay, but do you want to give any testimony about the events leading up to this ticket, March 27, 2023?
No.
All right. Well, I will find the defendant guilty of speeding 92 and a 75. The scheduled fine is $87. Court costs are $108. The total due will be $195. Sir, you do have the right to appeal this proceeding. You can appeal it to the Kansas Court of Appeals. You have up to 14 days to file that notice of appeal. Your appeal bond will be in cash, the same as what your court costs and fines are. That's $195. Can you have this paid, this fine and cost paid in 14 days, or do you need some time?
I'll follow appeal.